There are a few fundamental differences between Title IX cases at public schools versus private schools, but there's also a lot of similarity, and I'll start there. At both kinds of schools, you are guaranteed certain protections by the federal Title IX regulations. These regulations, though, only set a floor, not a ceiling, for the amount of protection you have to be given in order to fairly defend yourself. At a public school, you have an additional level of protection guaranteed by what's called the Due Process Clause of the federal Constitution. That essentially just means that a school has to treat you with fundamental fairness from start to finish, and that if there's enough unfairness at different parts of the process, then in the aggregate, that could mean you were denied a fair chance to defend yourself. The idea of notice of how much information the school has to give you at the front end is one way that the amount of information can differ between a public and private school. So for instance, under the federal Title IX regulations, a school may not have to tell you very much about what you're being accused of and why on the front end. Whereas under the Due Process Clause, you typically are required to be given more information so that you can fairly defend yourself when you're asked to first talk about the process. The differences can also then matter when you, or if you have to sue, because you will have additional legal arguments you can make under the Due Process Clause against a public school that you won't be able to make against a private school.